Thank you, Chris, for the introduction. This is Robert. I've got David Furman with me here today. David?
Hello, everyone.
Well, as Chris mentioned, today we're going to have a conversation about reserve studies and the business judgment rule, hoping to clarify the difference between the safe ground and dangerous ground in this minefield that volunteers walk through as they make the critical financial decisions that affect the future of their association. Now, this problem begins with the fact that most associations have underfunded reserves. This means that they have more deterioration than reserve funds on hand. That deficit becomes critical when an association doesn't have enough money for large reserve projects, and the association needs to levy a special assessment on the current owners. Those current owners are unhappy to be caught paying the bill for deterioration that happened long before they became members of the association, and they're often looking for someone to blame. That means suing prior boards for the fiscally irresponsible behavior of failing to collect adequate reserves and prepare for this big project that's happening. Now, David, is that a fair characterization of the problem?
Absolutely. And what we need our listeners to understand today is that board members, when they serve on a board, is typically very well documented along with the documents that or the budget that they have proposed. So there's usually a pretty clear record of who's involved in setting a budget that underfunded reserves throughout the years. Board members have put the responsibility to care for the assets of the association, and failing to do so may put them in a position to have some significant liability exposure.
Now, are you talking about personal liability or corporate liability here?
In this context, personal liability. Board members can be sued individually, personally, for the decisions they made while serving on the board if their acts are deemed to be grossly negligent or not in good faith and in the best interest of the association.
Well, let me follow up. Why is this an issue? Aren't board members protected from lawsuits by their association's directors and officers liability insurance policy?
Yes, but directors and officers insurance is really peace of mind insurance. Those in the audience today who heard your D&O insurance webinar a few months ago will have heard this before, but D&O liability insurance pays the cost of a defense when an association gets sued for both the association and the officers. However, if there's a wrongful act or if they're running in the role of the association, the D&O policy may not pay for the defense.
Okay, so it's a board member's job to make... I'm sorry, go ahead.
No, I was going to say that's where the business judgment rule really comes into play. Board members are the decision makers caring for, and in some instances, $1 million real estate corporation, which is the association. Board members need to do what they've been empowered to do, which is ask questions of experts and professionals where necessary, and act selflessly, subserviating their personal interests to that of the corporation. When they don't act in the best interest of the association or are acting contrary to the association as covered in documents, their defense may not be covered at all. And in any event, the D&O insurance covers just the cost of the defense, not the cost of any damages.
So board members can't just go along their merry way as long as their association has D&O insurance?
Correct. D&O insurance just pays for the defense. Today, we're going to talk about how to have a good defense in the case you're ever sued. Remember, one important thing, insurance protects you in the case of an accident, not when you do something purposefully.
And it seems like fundamentally the job of being a board member is doing a lot of purposeful actions.
Absolutely. If you're acting appropriately, everything is purposeful.
Got it. Okay. Well, with that introduction, let's focus on today's topic, underfunding reserves and the business judgment rule. David and I want to make sure this time is valuable for everyone attending here today. So as we get going, note that on your screen you'll see a dialog box. It might be labeled questions. If you've come with a specific question that we don't answer, or if at any time a question comes to mind, please type it into this dialog box, which Chris will be monitoring through our time today. We'll try to answer as many as we can in the time available after we've finished our prepared content. In addition, you note there's a hands raised icon that allows you to respond to a question we might ask. So even though you're not here in the room together with us, we plan to involve you in our conversation. So let's start off today with some audience participation. Everyone reach over, grab your mouse, and click your hands raised icon to let us know you're ready to start the program. Give me a hands raised, everybody. Okay, I'm starting to see them come up. Great. Okay, thank you very much. I'm going to put hands down. It's time to start. So, first off, let me ask David, what is the business judgment rule?
Well, the business judgment rule is a very important legal principle that will provide immunity from personal liability for board members or managers if they should be sued for the work they do as board members. Immunity from liability is a great thing, especially for volunteers. Remember, D&O insurance pays for the defense, but the business judgment rule is a key argument made when putting forth that defense for the board member. One pays the attorney's bill. The other is the argument that helps your attorney win your case. Serving on a board is hard enough. You don't want to add liability where you don't have to. For the business judgment rule, for a board member to enjoy the benefits of the business judgment rule, three things must exist. The person must be acting within their authority and power, which is defined in the Declaration, the bylaws, the Articles of Incorporation, and your particular state law. The person must also have made reasonably inquiry, which is also known as the prudent man theory, and relied upon such information. Finally, the person must be acting in the best interest of the association. With these three things, you'll be able to build a sturdy defense.
Now, is the business judgment rule state-specific?
No. It's a national principle that was founded in common law, but different states are going to have slightly different statutes or slightly different rules on the matter.
Got it. And do those rules and does the business judgment rule also cover a manager's actions?
Possibly. Again, the manager is an expert which is providing advice to the association, but the manager must also act with those three legs of the stool in order to benefit from the business judgment rule.
So it's a principle of following the business judgment rule for both board members and managers. It's not a matter of a specifically articulated law that you follow or a specific law that you break. Is that the case?
Correct. Following the laws of your state with respect to board member action and reserve studies is part of demonstrating the business judgment rule principles, that the board member has acted within the power and in the best interest of the association. That means following the governing documents and the laws of your state. The business judgment rule is usually not itself a law that you need to worry about following or breaking, but rather, as you mentioned, a principle against which your decisions as a board member will be measured. This means you need to care about the law in your state that says you must get a reserve study every X number of years, or acting in accordance with your governing documents to do things like collecting adequate reserves for the association.
Got it. Okay, well, let me turn this back to our audience and make sure they are getting this. That again, grab your mouse and show me with a hands raised that you understand that the business judgment rule is not a law, but it's a principle that applies all 50 states. Hands raised if you understand that business judgment rule is a all 50 states principle. Great. I wish you guys could all look around and see, but I'm getting hands raised from just about everyone. Okay, thank you very much. I'm going to put hands down. David, back to you. What would you like the result to be from our discussion today?
Well, what board members need to take away from today and what they really need to understand is how following the principles of the business judgment rule will really help them sleep better at night by keeping their liability exposure and personal liability exposure to an absolute minimum.
And here I was thinking that we were going to talk about underfunding reserves. It sounds like we've got a session on how to sleep better.
It is a good thing to sleep.
I agree. Well, one of the problems is you can be sued for just about anything nowadays, right?
And that is the problem. Since you can be sued for anything, you want to make sure that you minimize your exposure and provide the best possible defense.
And that best possible defense that you can hand to your attorney is by following the business judgment rule.
Correct.
Okay. Well, in your experience, how common is it that a board member would personally be sued?
Normally, lawsuits are just filed against the corporation. However, it is becoming more common that when a lawsuit is filed, the plaintiff in the case or the homeowner will name the entire board personally.
Okay, so that's something we have to look out for. How does that board member avoid being sued? Is it a matter of ducking, keeping your head low, letting things slide, and just trying to get by during your term as a board member, just trying to be invisible?
You know, realistically speaking, you want to do just the opposite. Remember, the business judgment rule, the first principle of the business judgment rule is to act in your area of authority, the key word being acting. Failure to act is not protected under the business judgment rule. That could be interpreted by a judge as not acting in the best interest of the association. Being a board member means making decisions on how to move the association towards the future. You are a fiduciary to the corporation, and you need to act as such.
Well, is abstaining from voting the same as failing to act?
Yes. Each member has a fiduciary duty to act as they have been put in a position of trust. Actions take decisions. Unless there is a good reason to abstain on a particular decision, such as you have a conflict of interest in that your brother owns a roofing company that wants to replace all the roofing in the association, it's your obligation as a board member to vote for the matters at hand, which means casting the votes.
Got it. Okay. So as a board member, you need to take action. I get that. But is there one right decision and everything other than that will get you sued? Is there a right versus wrong?
For most actions or situations, there is a range of decisions that can be made. All decisions range somewhere from being wise to being foolish to being just about right. The key with the business judgment rule is that if your actions and your motives are pure and in good faith, even if the decision is not necessarily the best or quite frankly wrong, a judge will not second guess your decision as a rule against you. So the business judgment rule doesn't measure the rightfulness or the wrongfulness of your decision. It measures if your decision process was wise and well-intended.
Well, that's encouraging to hear. It's nice to hear that it's a process you go through, not a matter of someone coming after you with possibly more information at a later point in time and proving that you were wrong. But let me follow that up. What do you do when, as a normal board member, when you don't know the right decision to make in a matter? I know you've talked about your process, your decision being protected if you've gone through the process, but how do you show your good process and good intentions when you just don't know what to do?
Well, board members are not expected to be experts in every field. They're volunteer board members who have a life outside of the association. They don't have specific expertise in every area that an association operates. However, they are required by the business judgment rule to make a reasonable inquiry and to reach out and to get advice to help them make wise decisions when they don't have expertise in the field. You need to know when it's time to get help.
So is that one of the reasons board members get reserve studies?
Absolutely. While many states have reserve study requirements, in every state, for a board member to make a wise, informed decision about their reserve contributions or their reserve disclosures, it means updating their reserve study, reaching out and getting the advice of a professional in their field to make the wise decision in an area where you don't have specific expertise. You need to make you need to make the reasonable inquiry.
So it sounds like you're painting a picture where there's two kinds of reasons for updating your reserve study.
Absolutely. Some state laws have minimum requirements and a board member's basic need for updated information on the subject. What do you see across the country?
Well, when we look around, we see 30 states with some type of reserve study requirement. Your comment fits with our experience in that we've prepared reserve studies now in 43 states. So it seems like it's a good fit between understanding that in some states there's a minimum requirement, but in all states, just fundamentally, there's board members who need the information. So in addition to local laws, there's that fundamental need for information.
And how often do you update reserve studies for your clients?
It's the same kind of answer. We have thousands of clients across the country, and about 30% hire us every year to update their reserve study for exactly these kind of reasons we've been talking about. Not because it's required by law to update at that frequency, but because it's part of board members just making reasonable inquiry and needing to know what practical action they can take. When we do an update every year, that reserve study update tends to be very inexpensive and just a minor tune-up. For the clients who only hire us every 3 to 5 years or so, obviously a lot more has happened. Things get out of adjustment, and so we typically find a significant change to their reserve fund strength, and we need to recommend some significant adjustments to their reserve contribution rate. Their physical assets and their financial condition change each year, and we find it's good to review and adjust it every year. Reserve contributions are typically 15 to 40% of an association's total budget. So it's a big budget line item, and we believe worthy of annual review. David, what do you say to associations who perhaps just choose to not update the reserve study for years at a time?
Generally speaking, they're heading out on thin ice. It really is risky behavior. As you said, reserve contributions are key to providing for the ongoing care and viability of an association. It's the kind of thing you want to do right. Not making a reasonable inquiry is defenseless. It's the board member's job to get the information they need to make wise decisions for the community. The head in the sand strategy is not an effective or successful defense. What do you say to board members who dismiss the value of a reserve study, though, saying that they're just guessing at the future and it's really a waste of time?
Well, that's a good question. There's an inaccurate stereotype that reserve projects are future expenses, problems that you can worry about at some future point in time, or problems that can be addressed by someone else at a future point in time. The truth is the reserve expenses are by and large very predictable expenses due to major components gradually deteriorating in plain sight on a daily basis over the course of many years. So reserve deterioration occurs very predictably on a daily basis, kind of like, I think of it like a cash register that rings every morning, going ka-ching every time the sun comes up. The value of that ongoing daily deterioration is something that can be easily calculated. It's not some future guess. Reserve expenses are, by and large, not surprises. Board members and managers are, I believe, going to have difficulty defending any inaction in light of the crystal clear fact that it is just everyday, daily deterioration. David, what do you say to associations who go ahead and get that reserve study update but then don't follow it?
You know, that's really just as bad. In one case, they've gone out and they've exercised their business judgment rule requirement of making a reasonable inquiry, but then they're ignoring it, which effectively sets themselves up as knowing more than the expert by saying, I think we already have enough reserves, or I know somebody that says the roof can last another 10 years. Are all different ways of saying, I know better. I know better than that expert I paid money to go get for the reserve study. And when you say, I know better, you may lose your ability to be fully defended for that decision under the business judgment rule, because you've put yourself in a position of higher knowledge than that of the person you went to the advice for.
So you're saying that you need to get a reserve study update in order to get the information you need, and then you need to follow it in order to show that you're taking that advice. But I feel a little uncomfortable there. Isn't that kind of like backing a board member into a corner, kind of eliminating their freedom of choice?
Well, a board member's job is to act in the best interest of the association, again, after making this reasonable inquiry. Now, while if you see a mistake in the reserve study, something along the lines of the starting balance is incorrect or the count of the boilers is incorrect, the reserve study company is going to make that corrected, and usually at no cost. A board member is always free, though, however, to do something foolish, but there are consequences to these foolish actions. What do you see when associations don't adequately reserve for future expenses?
Well, we see the same kind of things over and over when we look around and find clients that haven't been setting aside reserves. and you can see them on the screen there. But basically, we see them as an increased risk of unfair special assessments, an increased risk of unsightly and expensive deferred maintenance, additional difficulty getting favorable loan terms for both, remember, prospective buyers and owners who are trying to refinance and take advantage of today's low rates, declining home values, lower home values for everyone, and exactly the increased board member and manager liability exposure that we've been talking about today. Let me turn it back to our audience members here. Do you see these as the also familiar normal consequences to underfunded reserves? Show me a hands raised if these all look familiar to you as consequences to underfunding reserves. Great. Hands going up all around. Okay, thank you all very much. I'm going to put hands down. And David, let me come back to you. What do you say when clients come back saying, well, we can't afford to make the reserve contributions you recommend?
Well, remember, it's a board member's job to care for the association. There's no getting around that. The business judgment rule would require a board to act in the best interest of the association. If the board fails to act and fails to collect enough funds to keep the association viable and properly maintained, everybody in the community suffers. As you had mentioned, that could result in a special assessment, deferred maintenance, declining property values suffer. So it really does, if the board does not budget for these reserve contributions, it exposes them to liability.
Got it. Okay, well, I know I'm going to get some questions from clients, and so let me push this back into your area. Help our clients understand what's going on here. If we recommend $5,000 a month reserve contributions, and they're currently making only $1,000 a month reserve contributions, that's a pretty steep change. And do they have to be able to make that entire step? What's their wiggle room there? Can you talk me through that?
Well, that is a very big difference. And in situations like that, a board member can look around and look at the real financial pressures of the association. And if they feel that they can put in place a plan to address that big gap and take realistic steps of progress, which is to boldly increase the contributions maybe to $3,000 a month, and then maybe the next year get to that full $5,000 a month. It's these steps that the association has to take to move the association forward. It's not a perfect solution, but a reasonable plan given the starting point of the association and the limits of the association is what's going to be looked at. But as I mentioned earlier, ignoring the reality of the problem or failing to make the changes, that's where the board really is put at liability.
What I hear you saying is that principle of it may not be a perfect solution, but they are exercising their best judgment and saying, I don't want to break the back of the association, but I do want to move it forward. It's all coming together in my my mind here. Is that fair?
It is fair.
Okay, great. Is there any issue? Well, let me take this conversation a little bit forward. We often have clients say, is that the best you can do? Is there any way you can minimize those reserve contributions so we're not placing too big of a burden on them? And let me just touch on that subject. The great thing that we're working with is that the same concepts that allow reserve contributions to be minimized are the same concepts that have reserves be collected most fairly over the ownership base, and that means budgeted contributions spread over time. When it's done this way, every owner pays their fair share of the cost of deterioration over the number of months or years that they've been a member of the association, and in addition, even with today's low interest rates, the bank actually does make contributions to the reserve fund in terms of the interest earned on that reserve fund. So that's the way contributions are minimized, and that's also the way reserve contributions are fairly spread out over the ownership, almost in a sense like they're paying for the deterioration that's occurring on that daily current basis. Well, let me move on to a slightly different subject. We've touched on the issues of acting and making a reasonable inquiry. Now tell me what it means to act in good faith.
Well, good faith is all about fairness. If you, as a board member, are sued, this is one of the 3 tests a judge will use to determine if your decision process was reasonable. Good faith means honestly confronting the facts and placing the interests of the association above your own.
What's it mean to place? Can you articulate that a little bit more? What's it mean to place the interest of the association above your own?
Absolutely. Every board member first faces personal pressure to keep their own dues low. They all pay assessments. You as board members all pay assessments to the association as well. But if the association needs more money in order to offset the ongoing daily deterioration and get prepared to accomplish the major repairs that the association is going to face and do so in a timely manner, it means that board members need to vote to raise their own homeowner assessments. So boards that delay the necessary repairs or push off assessment increases or special assessments for future years may look to a judge like they were putting their needs first. For a board member, they need to confront the facts and do what they can to meet the needs of the association.
Thanks. Okay. We've talked a lot about properly sized reserve contributions, how they can be minimized, but what about the updated reserve study as an important disclosure to owners and prospective buyers? Here I'd like to, again, put it back into the hands of the audience. There's 3 results, 3 key results you get from a reserve study, and I'd like to do a quick contest among our audience to see who can be first to correctly type in the 3 results from a reserve study. So grab your keyboard and type into your dialog box the 3 results from a reserve study. We'll see how many of our listeners have been to prior webinars and can recall the primary results from a reserve study. If you only know 1, I'll take 1, but let's see who is first to be able to type in all 3. Oh wow. Got a bunch with 2. Actually, I have 1 person with 3. And I scrolled right through it. Bruce Hobbs. I recognize that name. I believe that's a Los Angeles area webinar attendee. The 3 parts from a reserve study are the component list. It forms the foundation. It lists the scope and schedule of the reserve projects the association is responsible to face. The reserve fund strength is the evaluation of where the reserve fund is at this point in time, and it's typically measured in terms of percent funded. And finally, a lot of people are very familiar, of course, with the recommended contribution rate, or the multi-year reserve funding plan. One of the 3 results, and let's focus on that right now, is the evaluation of reserve fund strength, measured in terms of, as I said, percent funded. What's a board member's, David, what's a board member's role with respect to disclosures and the business judgment rule, disclosures like the reserve fund strength?
As we had discussed previously, good faith means honestly confronting the facts that face the association and sharing those facts to involved parties. We all know what happened to Bernie Madoff when he didn't tell the truth to people, and the same is true of board members. You need to tell the truth and disclose to homeowners and prospective buyers about the strength of the reserve fund. If you know something and if you hide it, it will eventually be exposed, and board members look foolish and quite possibly could face legal liability for failing to disclose the actual fact of the reserve study.
Got it. Okay. Well, we've gone through a board's responsibility to act, their responsibility to make reasonable inquiries, and their responsibility to act in good faith in the best interests of the association. What are the reserve study issues you see intertwined here? Are there any, what touches your heart here?
Well, can you elaborate on the risks between the fully funding and marginally funding of a reserve study? Is one better or fundamentally more risky than the other?
Sure. It's that's a matter of balance. It's not necessarily a right and wrong answer, but again, in the theme of what we're talking about today, it's understanding the pros and cons and having a reasonable process. So let me briefly touch on what they are. Fully funding means having a reserve fund that's the same size as the deterioration at the association. It shows that the contributions have kept pace with the deterioration. Fully funding doesn't mean the association has the entire replacement cost on hand. It just means that the contributions have kept pace with the deterioration. It means balance between the cash and deterioration. On the other hand, the marginally funded is typically called, or technically it's called baseline funding. Full funding and baseline funding are designed to provide for exactly the same expenses. The same roof, same paint, same asphalt, but baseline funding means the association has a different objective, the objective just to keep the reserve fund cash positive. So baseline funding relies on the timing of the different reserve expenditures, planning to make sure there's enough cash at the right time for the expected expense, while fully funding focuses on preparing along the way. What we found is that there's more special assessments and deferred maintenance among baseline funded associations simply because they're working with less margin for error. For instance, a roof project may occur a year early, an asphalt project may occur at the same time as a major painting project, and there's cash flow bumps that the association is not necessarily prepared for. So if an association is trying to avoid special assessments, it's better for them to fully fund their reserves.
But isn't fully funding an association's reserve study incredibly hard or much harder to do?
Well, David, you're right. It is harder. Fully funding is a higher, more conservative objective, but the answer is it's really not much difference. Remember that both are preparing for exactly the same expenses. So that's the primary issue there. The only difference between the two is in the size of reserve fund, or a little margin for surprises. So we found that in our experience, fully funding contributions are about 10% higher than baseline funding contributions. So in the hypothetical we spoke about a few minutes ago, that means a difference between reserve contributions. We might recommend $5,000 a month or $5,500 a month for a typical association. That's a 10% difference. It's not a big deal. It's not a night and day difference. Both lead towards accomplishing the scheduled reserve projects on time. One leads towards accomplishing them with a lower chance of special assessments along the way. But David, looking at the time, any final comments at this point in time?
Absolutely. Remember, it's not all doom and gloom. You're not going to get every decision exactly right. The key is to have protection under the business judgment rule, which means you have to undertake a decision-making process that a judge can review and say, yes, your decisions were reasonable. The three principles that really need to be stressed are acting in the area of authority and power set forth in the governing documents. You have to make reasonable inquiry where necessary for items you don't have a particular expertise in, and acting in good faith and in the best interest of the association. Remember, being a board member is hard. You want to take advantage of all the tools available to alleviate liability. You're not going to get every decision right. But having a good process will mean that in the future, if there is a special assessment, anybody can look back over the association records, find your name, and then decide not to sue you because you acted in a reasonable manner after inquiry and in accordance with the association's governing documents, in that you updated the reserve study. And they will make a bold move to add, and then you made the bold move to adequately fund the reserve needs of the association. What do you think, Robert?
Well, it seems to me that the same decisions that we've been talking about, the same process, leads you towards an association that solves the problems of underfunding reserves and minimizes a board member's personal liability exposure under the business judgment rule. The association benefits and individual board members benefit from acting courageously, making appropriate inquiries, and making the bold decisions in the best interest of the association. I really think that with decisions, more and more decisions like these, along the business judgment rule principles, we're going to see more associations that avoid the problems of underfunding their reserves. Well, we are really at the end of our time here. I hope that everyone attending today has a better understanding of reserve funding liability exposure and how to avoid it by following business judgment rule principles. Thank you all for joining us. David and I have built our careers helping associations make wise decisions in this area. David, of course, in the legal realm, and myself in the world of reserve studies. We help our clients avoid problems and get out of a problem if they're already in one. We want to be part of helping you personally lead your association towards a successful future. We're on your side, and our job is to help. So if you're in Colorado and in need of some wise legal counsel for your association, please go to www.Hindman-Sanchez, or on there, subscribe to their blog. If you're in need of a reserve study proposal or have some follow-up reserve study questions, please visit the Association Reserves website at www.reservestudy.com. And now I'll turn the floor back to Chris, and with the time remaining, have her act as the moderator for the questions that you've typed in while David and I have been speaking. Chris, back to you.